All right, good morning and welcome to this joint meeting of the House Environment Committee and the Senate Natural Resources and Energy Committee. It's our first joint meeting of the session. I would like to take a moment to ask folks to introduce themselves, and we will start around the legislative table here with our newest member.
Hi everyone, I'm Mike Boyd. I represent Hartford, Barber, Alfred, and Bridgewater.
Christy Morris, I represent Springfield, and that includes North Springfield.
Yep, I'm Sarita Austin. I represent Colchester 19, which is the Mallett's Bay section, and I'm also on the Colchester Planning Commission.
Kate Logan, I represent Burlington, Old North End, and downtown Burlington.
Terry Williams, representing Rutland District.
Ann Watson, I am representing the Washington Senate District, and I'm chair of the Senate Natural Resources and Energy Committee.
I'm Amy Sheldon. I represent Middlebury and I chair the House Environment Committee.
And I'm Larry Labor. I represent Orleans Estes District 1.
Larry Satkowitz, representative from Randolph, also representing Braintree, Brookfield, Granville, and Roxbury.
Ella Chapin, I represent East Montpelier and Middlesex.
Mike Taglavia, I represent Orange 1, which is Corinth, Orange, Washington, and Versio.
Representative Rob North, representing Northwest Addison County, the Greater Virgins area, and I'm Act 250 alternate commissioner in Addison County.
Chris Pritchard, I represent Rutland Bennington, which is Middletown Springs, Paulette Rupert Timoth, and I share wells with Patty McCoy.
And I just want to acknowledge we're missing a couple of senators because they are actually at the Committee on Administrative Rules, which is running over a little bit. They're not advocating their role. Let's go around the room and start with, yeah.
Thomas Weiss, Montpelier, following this, since futures, things back in 2017, but I've also been involved with a few Act 250 cases of civil engineer.
And this is Patty, Danville resident. I'm the chair of the Planning Commission in Danville, and then also work for Vermont for clean environment.
Morning, Jamie Vidal, the new vice president for Vermont with Vermont Audubon.
Hi, Peter Tucker here with the Vermont Association of Realtors.
Megan Sullivan, the vice president of government affairs for the Vermont Chamber of Commerce.
Tigger Droysky, attorney for the Chamber of Commerce.
Dana Lee Perry, I just started with the Crafts Group as an acting.
And Stanek, retired guy from Garrett City.
And Ellen?
Ellen Shikowski, I was a legislative council.
And Ruth?
Hi, everyone. I'm Senator Ruth Hardy. I represent the Addison District.
Our staff.
Jude Newman, Senate Natural Resources. Pat Morgan, Committee Assistant for House Environment.
Great, thank you. And we'll introduce the presenters from the Land Use Review Board in just a minute. I guess, thank you all for being here. It's great to see a lot of familiar faces. It's been a journey, and we're now, we are welcoming the Land Use Review Board here to get updates on Act 181 and the many tasks we have given them. I think you've all been on board for about a year now, right? And I know you've been incredibly busy, and we look forward to hearing more about how it's going now. And so I think with that, maybe I'll let you introduce yourselves and we'll go right into the testimony.
So I'm Janet Hurley, the chair of the Land Use Review Board.
I'm Brooke Dingeldine, a member of the Land Use Review Board.
I'm Pete Gill, executive director of the Land Use Review Board. Welcome and thank you for giving us this opportunity to testify in front of you on Act 250 and the implementation of Act 181. Kind of as an overview of what we're going to go through here today, I'm going to give you just a quick background on Act 250, make sure everybody's level set. I know we do this at the beginning of the year most times, and you all have gotten pretty steeped in Act 250, but just want to level set and then give a couple updates about what's been happening besides the Act 181 implementation pieces that have been ongoing as well with the program. And then I'll hand it over to Janet. She'll talk about the Act 181 implementation. We'll get into the weeds on all of that and get further into that with our most recent report on the appeals. And Brooke will take that on. And we'll have plenty of time for questions as well. So with that, what is Act 250? It's a permitting system for the state of Vermont. It ensures that development is done, comprehensive review of development occurs before a project is permitted. It requires the review of 32 sub-criteria for multiple potential impacts, right? Natural resources, historic, agricultural, transportation, government services, making sure all those things are in line before a project is approved. When does it apply? Well, it depends on the jurisdiction. So there's a number of different factors there depending on the size, the type, the location of that proposed project. So it could be based on the number of lots, as you can see there, 10 or 6. It could be based on the size of the acreage of that parcel where they're intending to put the project, 1 acre or 10 acres. Variability there is depending on whether the municipality has zoning and subdivision bylaws. So if you have those in place, then you're a little more relaxed in terms of the jurisdictional trigger for that area. It's also another jurisdictional trigger is based on the number of units for housing units for a project. And then there's certain other jurisdictional triggers. We won't go into the details of those today, but there is a list of those as well. A couple important exemptions to note there. There is not, commercial developments for farming. Those are exempt. Logging and forestry below 2,500 feet in elevation. And then, as you are probably aware, the interim housing exemptions that went into effect is another large area of exemptions from Act 250 for those projects in those certain location-based and type-based projects. So how is the organization structured? Throughout the state, we have these 9 different districts, as you can see on the map there. It's all governed by this newly appointed, as of January 1 last year, Land Use Review Board, 2 members of which we have with us today. We have a variety of expertise on that board, which is really exciting. Planners, legal, natural resources, engineering, comprising that group to oversee the program, which is really exciting. These are working members that are fully engaged in the 181 implementation as well as the oversight of the program as a whole. What makes all this run from the permitting side? Well, it's our district commissions. That's where you have, when applicants come in for the approval of their projects, they come into the district commissions for that review. These are appointed individuals throughout the state, and they're based on their particular regions. They're the ones that are reviewing and issuing those land use permits, with the assistance, and very importantly, of our staff, the district coordinators, the technicians that are helping that permitting process move through in a smooth manner. The district commissions coordinators, are also responsible for determining jurisdiction. So on that previous slide, whether a project needs a Act 250 permit or it does not need one. Here's kind of the structure of our organization. As you can see, you've got the 4 board members on the top, along with the chair, and then the 9 different district commissions. We have kind of 3 branches or categories within our organization. We've got general counsel on the legal side. We've got 2 staff attorneys, one of which was brought through from the legislature's appropriation recently, and that's been very helpful. We just recently were able to hire that individual, so that's really great for the program. We've got 2 enforcement compliance officers and a legal services specialist. Next branch there is the executive director. That's my role. I oversee the state coordinator and the 10 district coordinators and interface, as you can see on the dash line, directly with the commissioners. The next division or branch there is the business director, making sure that the wheels stay on the bus in lots of operational and administrative capacities for our program. And that includes the technicians who are helping with the issuance of the permits. So a couple numbers here. Apologize, we don't have the annual report out yet. That'll be coming to you all very soon. But we do have a couple of numbers kind of on a 5-year basis, running average from last year. You can see we issue about 300 to 400 permits every year. Only about 5% of those go through the major process, meaning that there's a hearing held by the commission for that review. About 0.2% of those are denials, so very small number that are denied. And then in terms of permitting decisions that are appealed each year, it's between 1% and 3%, so a pretty small number there, depending on the range and the year, 5 to 10 per year. We also do issue quite a large number, 270 plus or minus jurisdictional opinions, again, determining whether a permit is needed or not needed for our program. So a couple of important updates. This is a slide I've been itching to get to let you know kind of what's been happening besides the 181 matters. We've been continuing on our digitalization project, so making sure that boxes, and I'm talking about 530 some odd boxes of files, paper files, tens of thousands of documents within that are being scanned and being more publicly available to project engineers, to applicants, to the public generally, to see what's happening or has happened in terms of the permitting pieces for their projects. So that's really exciting. It really just is making everything more accessible, both internally for our staff as well, and most importantly, externally for the public. We've expanded some of our permitting capacity thanks to the previously ARPA-funded roving district coordinators, and those have been created and approved by the legislature as permanent positions, and we were able to slot one of the existing ARPA coordinators into that role more permanently. So thank you all for that support and effort last year. And then we were just recently able to hire another one, so we have 2 of those up and running. One is in training, but going pretty well there, and excited about that additional capacity and ability to provide just more continuity of services, I think, is what really is helpful there with those 2 positions.
Are you going to speak to the ARPA funded?
Yes, and so those 2 positions, good question there. So they were originally ARPA funded. Last year they were approved for both part general fund funding and part ARPA funded, and we wanted to make sure that we were using to the maximum extent that those ARPA funds. And this year we would really appreciate support from the legislature to continue those through our general fund appropriations. The next thing here is we've got a new application that's coming online that's going to launch January 15th. We've given notice to current applicants as well as prospective applicants about that change. And really what we focused in on with that change was to make it so that the applications that are coming into our program are more complete, more straightforward for our members to be able to review, and hopefully the idea there is to help projects move more smoothly and quickly. It is a comprehensive law. It is a comprehensive review, and so those applications are comprehensive, and we're trying to make them as comprehensive on the front end so that things can move more smoothly on the back end. And again, that's launching January 15th. The last is we continue to work on our ARPA funded projects. We are working through making those go as quickly as all of the other program pieces. We've issued over 100, actually I think we just hit the 100 mark for ARPA permitted projects. We've been reviewing 500 to 600 plus or minus various projects that are coming in through the ARPA-funded stream and reviewing those with our other agency partners and determining which ones, as I'm kind of narrowing that funnel, which ones are actually needing an Act 250 permit. And so it's actually a pretty small number of those that are actually needing an Act 250 permit, and we've been very diligent in terms of reaching out to folks and letting them know what our services are in terms of determining those jurisdictional opinions, and then moving them through the permitting process as quickly as we can.
What kind of projects are those, if they're not housing, that you're, those other?
Yeah, there's, I mean, there are some that support housing indirectly. So there's municipal infrastructure projects, there's 3-acre stormwater projects. That's a large area of the ones that have been permitted through Act 250 processes as well. And then as you can see there, there's 16 of them that were related to housing developments.
So on that front, so as I understand it, the ARPA money needs to be spent by the end of this year. I don't know if you can comment on projects that may need the, an Act 250 review. Are they on track so that hopefully that work can get done? You know, is that a priority for you all?
Yes, it certainly is, and that's really goes to what I was saying in terms of our initial outreach. We have repeatedly provided outreach to folks to let them know that, one, they can request a jurisdictional opinion from our program to determine whether they need an Act 250 permit or not. And then once we determine if it does need one, that we're there for them and that they can come in and we can help them through the application process. So it certainly has been a priority.
Great, thank you.
Question.
Oh, yeah, go ahead.
So it used to be that a jurisdictional opinion had to be requested. Is that still the case, or does every case go to jail?
Yeah, so typically anyone can request a jurisdictional opinion. There was some Act 47 provisions that required an Act 250 jurisdictional opinion to be issued or sought. But the interim housing exemptions, for the most part, I think there's one little piece of PHP that still remains for jurisdictional opinion that are required. But for the most part, no, it's the option of the permittee or applicant whether they want one or not.
And how would you consider your makeup? Are you a quasi-government agency, or how are you funded? Because once the ARPA money's gone, how's that fund stream going to come to you?
Yeah, our funding is both general fund and special fund. Special fund is our Act 250 permit fund, and that's a much smaller portion of our overall funding stream.
Thank you.
Any other questions on this aspect of the presentation before I hand it over to Janet for Act 181 implementation? Probably what you're all most itching to hear about.
Representative Austin.
Are you going to speak to the appeal process in terms of the process and maybe some changes that are being made possibly?
Yeah.
Okay.
Yes, definitely. So we'll go to Janet first on overall Act 181, and we'll switch it over to Brooke, who has been the lead board member on the appeal studies.
Great, thank you.
Yep. So with that, I will move screens.
So, and maybe go right on to the next.
Yeah.
So the board has been busy. We have accomplished some of our Act 181 charges. The first being we submitted a wood products manufacturers report to the legislature early in the summer. We will be discussing that with other committees of jurisdiction tomorrow. So Kirsten Sultan and I will also be presenting on that tomorrow. The appeals report we submitted this fall. Brooke will talk to you about that. And we've begun the regional plan review process. So before we were able to take in any of those applications, we had to develop guidelines. We developed guidelines and adopted them in September, and then very shortly thereafter started taking in the pre-applications, so the draft plans, and we've done that for 3 RPCs so far. The Tier 1A application guidance was developed, and we adopted that a few weeks ago. And as soon as any municipality is ready to apply after their regional plan has been approved, we'll start taking in those as well. So here's the Act 181 implementation timeline, and the first three are they're sort of grayed out a little bit because we have already come to you and asked for extensions on the Tier 2 report and the Tier 3 rules submission to LCAR. Those were to be due to you in February, and we are hoping to extend that out to September 30th. The extension would not affect the implementation or the effective date of the Tier 3. We are also finding that it's very probable that we will not meet that June 15th deadline for the Criterion 8C. So I think we will be asking you formally for an extension to September 30th for that as well. And that also goes into effect December 31st, so that would also not affect the effective date of the Criterion 8C. We are working on road construction jurisdiction guidance. That new trigger would go into effect in July, and we hope to have the guidance before that. Act 181 compliant regional plans, as you know, must be adopted by all 11 regional planning commissions by the end of this year. As I said, we've looked at 3 pre-applications. We expect to continue those through the year, and the final applications will start coming to us this spring as well. There will be times during the year where we will be looking at 6 plans at once. So there's a lot of work to do in that sphere. Criterion 8C, as I said, and Tier 3 we'll be continuing to work on this year. Effective date is December 31st. Sort of tangentially, the EJ law requires, as we are a covered agency under the EJ law, so we must produce a community engagement plan that offers meaningful participation to EJ populations as well as all Vermonters. And that's something that will be due July 1st, 2027. Just the interim housing exemptions that Pete mentioned, those will expire as the Act 181 tiers will be coming into play after this year. Act 181 implementation report then will be due to the legislature early in 2029. So, as I said, we will be discussing the Wood Products Manufacturers Report. We made some recommendations for some statutory changes, but mostly the report focuses on areas where we can do better to put out information and provide services to applicants to ease the permitting burden on wood products manufacturers. So through this year, as I pointed out, we will be inundated with plans and we will be reviewing them. We are reviewing them for compliance with state statute, and we are also reviewing them, reviewing the Tier 1B requests that will be coming in with those plans. Tier 1B being those areas where projects with up to 50 units of housing could be exempt from Act 250. So we are asking, do those plans reflect the statutory goals and the required elements of regional plans as set out in Title 24? Do the FLU maps in particular reflect the FLU areas, the future land use areas, as described in statute? So there are now 10 areas that are going to be used by all 11 regional planning commissions across the state, and it will be consistent, and we are looking to be sure that those maps as presented to us reflect the statutory descriptions of each of those and the purposes of each of those areas. The The downtown and village centers will be eligible then for the state designation program, the community investment program benefits, as will the neighborhoods. The neighborhood benefits will be conferred upon the planned growth areas and the village areas that are depicted in those future land use maps. So, and we will also be asking, do the proposed Tier 1B areas meet the statutory criteria for getting those housing exemptions? So Title 10 establishes some criteria that those municipalities must have in order to get that Tier 1B designation. Or it's not a designation, that status. So we are in the process, as I said, of taking in pre-applications. Very soon we will probably take our first final application. The pre-application is a more informal review and comment. Our goal, it's basically, I'm seeing it as a conversation. And we want to front load as much comment as we can on those draft regional plans before the regional planning commissions go through that adoption process. We don't want to have to say no to a plan after it's gone through that process and been adopted. So, so we're working really hard to get as much comment and front load that before the regional planning commissions go through the adoption process. And then once adopted, those regional planning commissions will come back to the LURB with an application for a final determination. And that will be a quasi-judicial process that the board conducts. We will hold a hearing and we will make findings and conclusions as to whether that plan meets the various statutory criteria and elemental requirements. Once that affirmative determination is made, the state designations are conferred for neighborhoods and centers on the village areas. On the centers will be conferred on the downtown and village centers, and the village areas and planned growth areas will get the neighborhood designation. We will also determine whether the proposed Tier 1B areas will get that status concurrently with the determination on the plan.
Senator?
I have a constituent who thought, I think Pony is a 2-acre town.
Mm-hmm.
You know, that's kind of gone away now, but they purchased land with intention of building. They had to pass the state perk and everything.
Yeah.
So the design is done. Are they grandfathered?
So to build a house?
Yes.
I don't think that would trigger Act 250.
Okay.
It doesn't, yeah.
Only if it was part of an existing subdivision or something like that. But, I mean, that's a good point. If you get constituency requests about Act 250 and jurisdiction, that map actually that I showed earlier comes from our website, and on our Contact Us page, you can get the districts and the district coordinator that's assigned to each, and that's a great resource for you all to send your constituents if they've got questions about
jurisdiction.
do you need an Act 250 permit or not? So.
Okay. Thank you.
Right. Pete, can you
Representative North.
Thank you, Madam Chair. Janet, in the process of approving the RPC plans, is one of the success criteria that you're using the achievement of building the number of housing units that we need in total across Vermont?
So the statute says that the village centers, downtown centers, planned growth areas, and village areas must accommodate the regional housing targets that a regional plan also has to put forth and then municipalize. So that's part of what the regional planning commissions are presenting to us, that those 4 future land use areas, downtown and village centers, planned growth areas, and village areas, can accommodate those housing targets, yes.
Specific to each area, and are you considering whether or not that totals up to the total number of housing units we need across Vermont? Is that
It'll be a region by region determination.
Okay, region by region.
Yeah.
Thank you.
So this slide just shows a still shot of our map viewer, and it shows a little bit of data from both Chittenden and Northwest regions. So that is a depiction of the proposed future land use map from those two areas. And we set up this viewer so that the digital map data can be overlaid with various other natural resource and historic and various other data that we can use to assess whether those map boundaries reflect the descriptions in statute.
And I'll just add too really quickly, this, the ability to set this up and make this a seamless process, there was a lot of hard work that went into making that happen, but it also came from our digital request in terms of appropriation funding last year from the legislature, and we appreciate that.
Right, thank you very much for that, because it would be hard to do without this digital tool. So let's move on. Are there any questions about regional plan approval or mapping or?
Representative Logan.
Oh, sorry.
Just describe what we're looking at a little bit, please.
Yeah, so you are looking at the northwest, almost the northwest corner of the state. There's a little bit of Chittenden County there, Grand Isle County, and Franklin County. And what you're seeing is the different colors represent the different future land use map areas as proposed by the Northwest Regional Planning Commission and Chittenden County Regional Planning Commission for the towns that are there depicted.
So
I think we're seeing Colchester, or we're just seeing Milton and
St. Albans.
no, but I mean down here.
Oh, yeah.
So from Chittenden County, we're seeing Milton, and then above that, you'll see St. Albans. And the pink is the village area, planned growth area categories, and the darker sort of burgundy reddish are the downtown centers, village centers. I can't see the colors very well here. So, and then the yellow and the greens are the rural categories. And I can't really see any, there's some orange in Milton, I think, and that's enterprise area. And then there are also transition area. Wait, no, the orange is transition, right?
And it's lavender is
is the enterprise. Yeah. So those are some of the future land use map categories that have been depicted so far.
And what's the difference between the two different shades of green?
One is basically the rural agriculture and forestry, the lighter green, and the darker green is the rural conservation.
Thank you.
And then the yellow is rural general.
And there'll be a test later on all those colors.
Yep.
And if you want a cheat sheet, just go to that live link there on the bottom of your materials, and you can play around. It's got the labels of each of the different colors, etc.
All right.
Representative North.
Oh, go ahead.
I have one more question on the RPC plan approval process. Do you foresee any issues in the fact that, like the Tier 3 rule submission, the Tier 2 area report, the road rule submission, that all that's being delayed, and yet the planning commissions are required to get their plans in by the end of the year? Do you see any squashing of timeline that causing trouble for them to get their plans approved?
No, because the only tier that's affected by this map are the Tier 1A and B. And the decisions about those boundaries are being proposed from the municipality to the Regional Planning Commission.
Okay, so it's going the other direction.
And then we have to make sure that, what they want reflects statute. So we're not saying you must draw your lines here on those. They are bringing those forth, and we are just assessing them for conformance with statute. So hopefully everybody's informed enough that what they present to us in that final plan review you know, we affirm conforms to the statutory descriptions for those areas.
So the push out of these submission of report dates is not going to adversely.
No, because those are on so the tier 2 report. So other than the tier 1A and B, which will go into effect as soon as we make any final determinations this year. And those will probably start as soon as April, May. And so region by region. I expect that Northwest Regional Planning Commission is going to come to us at the end of March with their final plan. They're going to be the first ones, we think. And so we have a certain amount of time to review that and issue that affirmative determination. And then, so those pink areas will be conferred, some of them will be, if the town opted into Tier 1B, those areas will be conferred the housing exemptions right away, as soon as we make that determination. And so this will start happening across the state. And so the Tier 1A will be the first tier to go into effect. Until Tier 3 goes into effect on December 31st, there really isn't a Tier 2 yet. Until the Tier 1s are in place and the Tier 3 is in place, that's what defines Tier 2. So in the interim, the jurisdictional triggers are as they have been, except that the road rule will come into play in the middle of the year. So the ask to move the dates out on the Tier 2 report isn't going to affect decisions made at the local level, because the boundaries of Tier 2 are sort of based on those local level decisions, and Tier 3, which doesn't come into effect until December 31st. Yeah.
And then on top of that, the extension request that we're asking is for the submission to LCAR on that. And so the effective dates in statute, we're not asking for those to change or move out.
Right. Other stuff, ready? Okay, so Tier 1A. So in addition to the Regional Planning Commission applications, as soon as we affirm the regional plan, municipalities will then have the option to come in and apply for Tier 1A status for those same areas that were eligible for Tier 1B status. So the centers, the planned growth areas, and the village areas. So we have adopted guidelines for those applications as required. They were due to be adopted by January 1. And we anticipate we will start receiving those end of spring. As soon as certain regional planning commissions have gotten their approval, there are some towns that are going to apply. So it's a similar process to what happens with the regional plans. There will be a pre-application phase where we're trying to get as much comment and review to the applicants, the municipalities, as possible before they come in with their final plan, that we would then issue a determination of compliance on, and that would confer the Act 250 exemption for the entire area that was proposed for Tier 1A. So that is happening. Any questions on Tier 1A?
I'm wondering, FLUA, future land use.
Sorry, what are you asking?
Oh, area, okay.
Oh, okay.
Oh, it's in the second bullet.
FLUA maps.
So the Tier 1A area.
Oh, it's just, okay. Thank you.
Yeah.
Yeah, sorry, sometimes we've used FLU and then map, but
Oh,
here
yeah.
we've got area, I guess. Yeah,
And
so sorry
actually,
about that, yeah.
it was probably a bad choice of words to use the word areas after Tier 1A, just because of the overuse of the word area in Act 181.
Yeah.
So I would say status. We try to say Tier 1A status.
Yeah.
Oh, okay.
I'll change that slide for the next presentation that we use it for. But yeah, do you have a question?
No, I just
Senator?
wanted to know what that
Okay.
question was.
Yeah.
Thank you.
Okay. Any Tier 1A questions? Okay. Next slide, Pete. So we are working on the Tier 3 rulemaking. I should point out, Sarah Hadd is the board lead on the Tier 1A work. So if people have questions on Tier 1A, Sarah's the one to direct that to. Alex Weinhagen is the lead on the Tier 3 work. He's worked very hard with a stakeholder group to go through at least 2 iterations of a draft rule. There's been a lot of public feedback, and he has responded to that with continuing revisions, and he's working on refinement. But basically, what the stakeholders and Alex have been focused on are areas that include significant natural communities, headwater stream areas, and habitat connectors that with road intersections. So what I think his primary focus right now is how to map those habitat connectors. What's most important to map to protect those habitat connectors. And we are hoping to continue the public engagement process on this through May and finalize a rule in the summer. As we said, we are requesting an extension on this because the current deadline was February 15th, I think. And that was just not enough time to get the public input and basically some of the GIS work that needed to get done. So we really think that the public engagement is critical, especially on this one. And we need that extension for that reason. So as I said, it doesn't affect the effective date of Tier 3. Any Tier 3 questions?
Over here.
Oh, yeah, Representative.
Yeah, thank you. So I'm looking at the regional map I'm assuming that the maps you have, it looks like 2 RPCs have submitted. So my question is...
3, but yeah.
Okay. The rural conservation areas.
Yeah.
Are those presently conserved lands, or are those Tier 3?
They have nothing to do with Tier 3.
Okay.
Tier 3 is completely separate from the rural conservation or the rural ag forestry categories on the future land use map. What we're looking to focus on for Tier 3 after stakeholder engagement and public engagement are these 3 categories of natural resources that are considered critical by the working group, basically. Significant natural communities, headwater stream areas, and habitat connectors that have road intersections. So it's not related to the future land use maps. It's a separate exercise.
Yeah, so are these lands already conserved?
Yes.
That's my
Yeah, on the future land use map, yes.
I just need a little bit of clarification to Representative Pritchard's question. These lands being already preserved, can you describe what you mean by already preserved on these maps?
They have conservation easements on them, or
That's
they're...
incorrect. You're talking about, I've attended a number of planning commission meetings and RPC meetings, and rural conservation has come up numerous times.
Yeah.
People who have no conservation easement whatsoever, who are using their land for either forestry or agriculture or a little bit of both. And they found their land in rural conservation, and they have a question. First answer was, well, that's just a suggestion, which I found very offensive, because I think this is my personal opinion, this is a way to, after it's codified, tell people that in my district and all over rural Vermont, well, since you didn't speak up at one of these planning commission meetings, you're out of luck. So one particular constituent had his land for 40 years, maintains it, best management practices for forestry and stuff, but he has not put his land into any sort of land trust or conservation, even current use. For the simple fact that it's his and his family's decision to do with their land what they please. So the statement that these are already conserved is not true. I know one of my constituents stepped up and said for the entirety of the time that parcel of land was in existence, it was used for either forestry practice, agriculture, equine uses, and everything else. And because he attended the meeting, and at first he said the map was not as interactive as it should be, but they corrected it. He would have, if he'd not questioned, he would have had his land in a designation that is definitely not what's on the map. So that's what I'm hearing about. Not tapping the brakes on some of these things going forward is a concern of a lot of people, not only in my district, but all over rural Vermont. So I just wish you would take that into consideration, because some of these land use designations are really worrisome to a lot of rural landowners.
Understood, and that's why this is so important that the regional planning commissions are working with their municipalities, and they're getting this, this is trying to be a top, bottom to top on the future land use map. And I mean, it's maybe small consolation, but that future land use map category does not have jurisdictional implications for Act 250.
And actually, I would just add that.
So if there was a mistake, and that guy's property is not under some sort of conservation protections, he can bring it up and they can fix it, with a map amendment or something.
Understood, but
So,
with respect to one of the concerns that's coming up with Tier 3 and notification of landowners, if we can send out a tax bill to everybody who owes taxes, then we should be sending out some sort of a notification to everybody, even if they're not in Tier 3. This is affecting everyone. And just because, it's an Act 181 and we passed it, therefore it is not a good enough explanation to a lot of people. That's what I'm saying.
So I want to add, though, that folks have been in a regional plan. Their parcels, their property's been covered by a regional plan for a very long time. And in fact, this process is engaging the public more in that planning process. So whatever the previous plan in your constituents area was, they were in a land use category. They may not have known it, they may not have participated in it, but in some ways what we want to have happen through this is getting people engaged in planning. They were already in some land use category before in their regional plan. It's just now they're working with it and they're aware of it and they're engaged. So that's an upside. I get that we're having frustrations with data or growing pains. There's going to be things along the way, but I think it's important to remember this was already going on. And one of the things that is happening for Janet right now is just that we've asked them to do a lot, and one of them is to provide consistency and structure to our regional planning processes that didn't exist before, and oversight of them. And we hope engagement of people in that so that they're aware of what, they can be involved in the plans for their towns and their properties.
right, and there continues to be this worry about that conservation category or being Tier 3, and they don't really have anything to do with each other. So the Tier 3, as you see here, is about significant critical resources that have been mapped, and it doesn't have anything to do with the conservation status of property. So this is what probably people should be more concerned about, not whether their land is in that future land use category that doesn't have jurisdictional implications. This is the one that has jurisdictional implications, and this is the one that I think people are worried about. So, and that's why we're asking, that's part of why we're asking for this extension, because we do want as much public input on this as possible, and we want it to be, we want it to reflect statute, which requires that we look at it in terms of equitability across the state. So, yeah. Any more questions about Tier 3 before moving on to the next? Okay, Pete.
Representative Austin.
I just want to get clarification on this question. Does this mean that a person who is a private landowner who owns and maybe has had it in conservation for 20 or 30 years cannot do what they want with their land because of conservation category?
No, there's,
Okay.
as I said, there are no jurisdictional implications for regulatory measures because of those future land use map categories in the rural districts.
Be clear on that.
You know, what they're about are, you know, just looking at lands that do have conservation measures on them, and if you put that all together throughout the state, then we can say something about how much of our natural lands in the state are conserved, and do we need to, you know, work on certain other areas of the state that aren't reflected in that. It's a planning tool more than it's a regulatory tool. It's not a regulatory tool.
Thank you.
So, yeah.
Madam Chair. Do you have an overlay or any input with respect to the lands that are already in the current use program?
Yeah, so the category that is called rural agriculture and forestry, a lot of the current use parcels are ending up in that category based on the mapping methodology that the regional planning commissions are using.
I understand that they're ending up in there, but that's not, well, I know of one particular piece of land that is in that designation currently right now in my district, and it's not in current use, but it's in that designation on this map.
Right. So that designation isn't limited to lands that are in current use. It's being used for lands that are being used for forestry and agricultural purposes. So some of them are in current use. A lot of them are in current use, but not all of them. Okay, Pete. Okay, so here's the Tier 2 report. What do we need to do with that report? We are tasked with addressing whether we think there needs to be some statutory changes to address fragmentation of rural and working lands while allowing for development. We must consider whether how location-based jurisdiction is working or going to be working in Tier 2, whether we are adequately protecting primary agricultural soils in Tier 2, whether criterion 9L is effectively being used to avoid sprawl and strip development in Tier 2. And then the one aspect of the Tier 2 report that we have not asked for an extension on is the accessory on-farm business portion. And so the legislature had asked the board to consider the issue of accessory on-farm businesses, and we are doing that and intend to report to the committees of jurisdiction by February 15th on accessory on-farm businesses. For the rest of the report, we will be going through a public engagement process on a draft before presenting the final to you at the end of September. And board leads on this are Kirsten Sultan and Sarah Hatt. Any questions about Tier 2 and our request for an extension on that?
So,
Yep.
Senator Bonner.
just to make, so 9L, if you extend till September 30th, 9L is supposed to be in effect by when?
9L is in effect.
Okay.
Currently.
Okay.
It's
Okay.
8C that
Yeah,
is not,
Okay.
yeah.
Okay.
So,
And the report will be looking at a review of 9L and how that's functioning, working.
right, right.
In this context.
And so another Act 181 component was the road construction jurisdictional trigger. So it's a new trigger for new road construction that would come into play for singular roads that are over 800 feet or all roads and driveways in a development that together are more than 2,000 feet long. We are working on drafting guidance around this jurisdictional trigger. The purpose of that and statute, the guidance will be furthering that they'll focus on furthering that purpose that is established in statute, and that is to avoid sprawl and fragmentation in Tier 2 and 3 areas, basically. So.
And a little of the history would help. It existed until about 20 years. I can remember.
Yeah,
but
there was
this
a road
rule was in. It was a rule.
Right.
That's why we call it that. But yeah.
Right, until about 2020, right? And then it was gone for another 20-something years, and now it's coming back. So. Till 2005. So it was in effect for 25 years. Then it was out of effect for 20 years. Now it's going back in. The board leads on developing this guidance around the the jurisdictional trigger for roads are Kirsten Sultan and Sarah Hatt again. So. And finally, we are working on rulemaking around a new criterion that was intended to prevent habitat fragmentation in the face of sprawl and to protect wildlife travel corridors between larger habitat blocks in the face of climate change. So that is from statute. The purpose, and Alex Weinhagen and Kirsten are the board leads on this. They've met with stakeholder group. They are working on drafting a first draft that will then be put toward the public, and the same process that the Tier 3 is going through. This criterion 8C process will as well. We haven't officially asked for an extension on this deadline to Alcar on this one. Currently, it's June. We are going to be sending a memo to you asking for an extension on this to the September 30th date as well.
Are there any questions on this so far? Yeah,
Just a
Senator
general
Williams.
question, not necessarily on this, but somebody already has an Act 250 permit, property is about 2,500 feet, and they want to, the way it was set up was to put it in perpetuity. They wanted to say, how long do you want this to be in effect? They said forever, because it's in a family trust. They want to be able to cut the logs. It's a once in a generation cut, basically. Is that going to be affected, or is it still going to be honored?
I don't think anything will change if it's above 2,500 feet.
Okay.
It would still need an Act 250 permit for logging.
So that Act 250 permit they have, is that still in effect?
Yeah.
I'd like to take a 5-minute bio break, but I really hope folks can limit it to that and that we can reconvene in 5 minutes.
And then you'll hear from Brooke.
So we can stay on track here. All right, thanks. We'll go on live for 5 minutes. All right, we are reconvening our morning meeting here with the Land Use Review Board, and I'm going to hear from Brooke Dingledine on appeals.
Thank you so much. My name is Brooke Dingledine. I was a land use and litigation attorney for 30 years with the Central Vermont law firm. And I had the benefit of, as a young lawyer, appearing before the Environmental Board, then the Environmental Court, the Environmental Division, which it evolved to. So I'm very familiar with the debate that's been raging for years about whether or not to return to more of a board model. So I was actually really pleased to be able to sort of spearhead the study because it's just so important. The one thing that I want to start off by saying is my great respect for our Environmental Division judges. The concern about the amount of time that appeals takes is directly relevant to the amount of due process that we are providing to litigants. And going into this process, many people, I think, were expecting certainly a lawyer to have a bias in favor of the court. And this has been a very interesting process to go through. We spent the entire summer from late April or early May through August engaging the stakeholders that the legislation dictated were the participants that were vital to the process. We also went beyond that and invited members of the public, of folks that have been very active in this over the years, as well as attending many of our current board meetings to stay apprised of what the LURB is up to in our implementation of Act 181. It was a very robust process, and we went into it with the trying not to debate which is the right answer. What we tried to do is step back and say, we want to build the best board model possible to provide an alternative to the court process. We are not trying to duplicate the court process. We are offering a different alternative that is not a war between two parties. The way that I am looking at this, and I think the way that the board produced this report in terms of its thoughtfulness, is to provide an avenue for permitting that doesn't turn things into litigation war. The courts are very, very important in resolving disputes. And, but this is not necessarily somebody seeking redress for harm. This is somebody asking to use their property in a certain way. And I'm not afraid to say, I think generally that individual, the applicant, has superior rights to be able to use their property as they deem appropriate under the law and the regulations that exist. We do allow others that could be impacted by that, who can demonstrate a harm could happen to them as a neighboring property owner. But that process is one that through permitting, those issues are hopefully addressed and controlled through the conditional process of instituting requirements for the applicant to be able to successfully develop their property with the right protections for our environment and all of the other criteria that pertain to whether or not our schools have the capacity to accommodate the influx in population from this project. So as you know, there are 10 criteria, really 32 sub-criteria. And so this is a very complicated process. But instead of turning it into a lawsuit, which is basically what happens at court, what we are trying to do is to institute another permitting authority that reviews the work done below by the District Commission, honors that effort and gives it due consideration, which means the Board on Appeal would not have to follow it. We're not deciding if they were right or wrong. We are deciding de novo, meaning with a clean slate. However, we are allowed to take into consideration what the District Commission or the District Coordinator, if it's a jurisdictional opinion, what their decision was, what information that they used to support it, and we can either adopt that information, the findings or the conclusions, or completely disregard them, or anything on the continuum in between. The real important aspect of the difference between the model that we are proposing versus our current court system is the notion that because we're not turning it into litigation, we are cutting out much of the pretrial busy work, I'll call it, that often delays the process and can also be used for reasons that are not necessarily about the the actual substance of it. Sometimes people do just want to delay or increase the costs of the permitting process. What we're trying to do is eliminate that part of it by basically eliminating discovery. And discovery is something when you enter into litigation, you're given the opportunity to find out what the other side is going to say. So when you show up at the trial, you're not surprised. And in the court system, we don't allow trial by ambush. That's sort of the term that we use. We want to make sure when we get to court that time is not wasted in front of the judge cross-examining people when you should already know what the answers to the questions are. But that's a different model. What we would like to do is say, we're going to require you to tell us the information ahead of time, sort of like the Public Utility Commission does. When their hearing officer takes on an application case that is a contested case because somebody has asked for standing and have raised issues that they want reviewed, which just for your information, they use the Act 250 criteria plus a few other things. Those criteria, most of them, not all of them, were imported into the Public Utility Commission review process for telecommunication towers and renewable energy projects by vendors. So in terms of this discovery, what I was envisioning and we were trying to suggest is that everyone's going to come together once a case is actually appealed, but the hearing officer will be issuing a scheduling order that says you're going to tell everybody who your witnesses are by the state, and any exhibits that you're putting into evidence need to be exchanged by this date. We are supplanting the discovery process by saying, tell us who your experts are, give us their reports, so that everybody has that information exchanged, and then we can go to the hearing and nobody is wasting time or unaware of what the evidence is that's going to be presented. So we're trying to create a shortcut. And this is not unprecedented. We are following the Administrative Procedures Act, but that allows us more flexibility to, I'll put it this way, to reduce due process, not eliminate it, but to eliminate those aspects of it that cause the greatest delay and can be used for improper purposes. If you look at it like we're like a super district commission, okay? And the other thing that I want to point out is the real important difference between the court making a decision and what happens in Act 250 is it's not about you win, you lose. The umpire, the judge, actually has to be more involved in, deciding whether these conditions are appropriate, what is appropriate. And that's a very different process and inquiry. And it's not to say that our environmental judges are incapable of that. They do an excellent job. I have great respect for both of our judges. But the process is such that it is more formalized. And in terms of the message that I want to provide to you, as a board member, my decision on this was very challenging. I came into it with a bias to the court. I will be the first to admit it, and I told everybody coming in. It works okay, you know, and all the lawyers know how to do it. But it was, in my observations, and I'm the first to the confessional, it is the lawyers who were driving the timing of the litigation, which is not a bad thing, okay, for litigation. But it's a bad thing when somebody is sitting around and watching construction costs rise and whatever the economic conditions are that are making it worse and worse because of the time delay. So let me get...
We have a question from Senator Murray.
Oh, sure.
Hi, thank you. I'm curious, a couple things. I think the process by which you sort of shrink or consolidate, or however you want to say, the discovery process is interesting. What happens, or what would you, I haven't read the report yet, sorry, but if, I know that in the discovery process in the courts, if somebody doesn't disclose something, there are implications, there are penalties, there's you know, things happen if things aren't disclosed. So what, in the process that you're proposing, or the PUC process for that matter, if you're modeling it after that, what happens if somebody doesn't follow the rules of disclosure or discovery?
Yeah, you know, it's a serious matter in court because discovery is under oath when you're answering interrogatories, which are written questions that have to be answered. And it's not a usual thing. I'm in my mind trying to think back on 30 years of practice when I've seen that happen. When it does happen, if you are surprised at trial that, you know, something hasn't been disclosed, typically what the courts will do is delay things. You know,
right. So
either let it, we're not going to let it in, or I'm going to give the other side time. You can even do a deposition today, and then we'll come back tomorrow, kind of stuff.
Right. No, I understand what happens in the courts when it doesn't happen. So in your process, if just something is not disclosed or during the sort of short and truncated discovery, or you're basically pre-discovery. Well, I mean, I guess in the court process you pre-discover too, but what happens if somebody isn't just disclosing things through discovery?
An objection would need to be made, or there should be a sua sponte response by the board that says this was not provided. You know, bring in a witness to say, you know, and that witness is not on the list, or a summary of what the testimony is, and they've gone far afield of that. The answer is we're not going to accept that.
Mm-hmm. I just think it needs to be really clear what happens if people don't play by the rules.
Yeah.
And then I was a little concerned by the way you phrased it, and I know you were sort of searching for how to phrase it, but that you were eliminating or reducing due process. And I would hope that's not actually what we're doing or what you're proposing. It's more that you're streamlining the administration of due process or something like that.
Yeah.
Because I think that that's where the tension is that we want to have a streamlined process. We want to have something that's fair. We don't want to hold up good projects, but we also want to preserve due process. And so how do we do that? And again, I haven't read your report, but if you're describing it as reducing due process, I think that's a little problematic. And I know you were struggling with the word, but I would love to have you think about that a little bit more and pick it apart and just make sure that whatever you're proposing isn't eliminating or reducing, but is streamlining or making it more efficient or something, but still giving, you know, fair due process when it's necessary. So part of it is semantics, but
I totally appreciate what you're saying. I did not mean in any way, I mean, we are preserving due process, and I'm sorry that I struggled in that regard.
No, that's okay.
What I'm trying to explain is we are reducing the amount of time and that the information exchange is allowed to take place. We want information because remember, we're an appellate board. The entire case has already been presented below. And
That's a fair point, yeah.
So when I was struggling with that, what I'm trying to explain is we are already getting the entire record from below.
Yeah, okay.
But we are
That's fair.
actually allowing more information beyond that. It is the logistical, how we're getting it, and time frames that we are reducing. So I apologize for speaking, and in that way, I did not mean to imply that we are not preserving due process, because absolutely we are. And that is the number one requirement of any appellate board, is to ensure that those that have standing and have an interest that can be articulated, even, and then it's the hearing process through which those impacts are actually proven. So let me rephrase my testimony to say, no, we are not shutting anybody out. And there was also a great deal of back and forth about neighbors, and there was a lot of objection because of some, I'll call them poster child cases. There are a couple that people have had grave concerns about, and of course last year there was a lot of discussion at the legislature about municipal standing and petition standing, for example, that, you know, some people are calling the mob rule, and on the other side of the fence, it's like, how do you keep government from, you know, making bad decisions for the wrong reasons? So the most important thing in my mind about this entire study was trying to figure out how to deliver a good decision that is well thought out by a collective of 5 people that brings different perspectives to the table, instead of relying on one judge, one decision maker about it, but that does so in a more expedient fashion. Now, before I go on.
So what's the appeal
Senator
process?
Boston?
There is an appeal process.
Right.
So if somebody doesn't like your opinion, can they go to the environmental court?
No, from our board, it would be like when the Public Utility Commission makes a decision, the appeal is directly to the Supreme Court. And we looked at other models like administrative law judges or hearing officers who recommended decisions to this board, and the problem was that that was resulting in adding an additional step to the process. And so it would come on appeal to the Land Use Review Board. The decision of the Land Use Review Board would be appealable to the Vermont Supreme Court. The findings of fact would have to be if we made a really big mistake, if we abused our discretion. And that's the same standard that the Public Utility Commission has on appeal to the Supreme Court. So there is that check and balance ultimately with the judiciary in the other branch of government.
I know some people that don't support that. Some of the attorneys that have reached out to me.
And you know, one of the issues that we looked at during this study, because there wasn't much emphasis placed on it, but you know, the ultimate appeal to the Supreme Court is a time-consuming process as well. It is also very expensive to write a brief and put your case in at that level. So, you know, we have that check and balance. It is expensive to go that route. But as far as I know, no one was interested in cutting out any kind of judicial review from this process.
I was just going to make a comment that I think in some ways what you're doing is with the discovery is you're setting the confines of discovery in a way that's reasonable and rational, and that in some ways I would argue you're improving due process because you're removing to some extent the power imbalance that can come with some cases where when the system gets abused, that is the opposite of due process. And I think reining that in and getting control of it and setting the confines in a way that's fair to both parties is actually improving due process.
Thank you. And let me just follow up by also just mentioning, the relaxation of the rules of evidence in our appellate proceeding also enhances due process and accessibility. We were also very cognizant of our environmental law obligations as a covered agency for that, and one of the most important factors in many, I think, the board's decision-making on this was the notion of accessibility. Not just for neighbors, this is about for the applicants, making the process better and faster for them. So let me just mention one thing in that regard. That is why, while we think the Act 250 permitting is important for our board to take back control of, if you will, as opposed to being a party at the court, you know, that the notion that we are making sure that people can get involved in the process if they so choose because they have an important stake, facilitating and making that easier to be involved in, I think was something that was very important to the decision-making, that accessibility, not making it so hard that people just throw their hands up and then they just complain about it and don't actually participate in trying to fashion a result that will actually work for everybody.
Yeah. So I would love it if we could just get maybe through the recommendations and then continue with questions.
Okay. So let me, can you switch to the
previous one?
No.
The
Oh,
next-
is that,
This is-
that's the
yeah,
recommendations.
yeah.
Okay, I can't see it. So the very first recommendation is for the Act 250 permitting, for us to become the appellate board of those cases. Now, it's a very small universe of cases, actually. 15 at most has been over the last few years. And then what happens to those 15 cases, 2 or 3 of them actually go to hearing. It is such a small universe. Not to say that, the cases that have become these poster children that did get appealed and 2 years went by before the permit was actually upheld by the Supreme Court. So what we're trying, so I just want you to focus on the notion that what happens now is we become a party and we're a litigant, and most of the cases are getting resolved through settlement, agreements, and the court has to review those and say it's okay, but it does not allow for the complete implementation and supervision, in a way, of this process by the board that really should be guiding it. I mean, we don't supervise the district commissions in terms of like telling them what to do. We don't tell them what decisions that they have to make or not make. We are apolitical in that sense. We are here to implement the law and do that job. So in doing that, when all we can do is write a policy or give training to the district commissions, ultimately it's like you let your children fly the nest, but this gives us the opportunity to fulfill the policy aspect of this program through the actual application and interpretation of the law to the actual facts in a case. And that's where the rubber hits the road. And this is the ability of a group of people with different perspectives and skills coming together to be able to provide a good decision, and one that is reflective of not just the words in the statute, but the intent of this legislature and what they are striving for in terms of this law being implemented. So it is a fairly small universe, but we also have suggested, in order to keep the option open for applicants to be able to consolidate an appeal, if they have to go and get permitting from the town, a zoning permit, as well as do an Act 250 permit. We want them to be able to come to us on the appeal if there is one, so that everything can be done at once. You can have one hearing, and then the board can write 2 decisions. We would write one for the zoning appeal, and we would write one for the district commission appeal for Act 250. But you only need one time to listen to what the application is about, so that saves the second hearing. Whether that can be coordinated in terms of where the 2 processes are, it happens infrequently because often that is not something that is logistically viable. Often people want to do zoning first and get their okay there, that kind of thing, and that's up. But this gives one more option to the applicants so that we're not eliminating that ability to consolidate. We went ahead and drafted board rules of appellate procedure. Those are primarily based on our old environmental board rules and also our current environmental court rules. And what I did was try to utilize the aspects of both of them to keep it as similar as possible to the current situation. So if you're going to appeal to the LURB, you do the same thing if you were going to appeal to the court. That's how we have kind of drafted the rules, to have as little change and alteration as possible for the practitioners that are regularly doing this kind of work. The other recommendation that we made was to later, after we get the Act 250 appeals and the process and pardon me, constructed, we would then consider taking municipal appeals. The ones that we had targeted would be the ones in the Tier 1A area, any kind of municipal zoning appeal in those areas. And then in the 1B areas, the housing projects, because that's where you have exemptions for housing projects up to a certain size. And so because of our familiarity with those areas, it seemed logical in terms of helping the housing crisis to be able to alleviate some of those cases from the environmental division at the LURB. We have 3 planners that are intimately involved in not just understanding these kinds of laws, but also writing them. So we certainly have the expertise on the board to address these kinds of cases beyond our Act 250 area. If that is helpful to the court and the legislature thinks that that would be useful for the housing issue that we are facing, we do believe we have the capacity. At this point, we've asked for that check-in to make sure that, given the lack of information and data about what's going to happen when we exempt Tier 1A areas, will that increase, decrease? We'll see more municipal permits, less, obviously no Act 250 permits. But it's very difficult right now to predict how all of this is going to play out and what ultimately will happen to the volume of the appeals. At this point, the only additional resources that we need besides the building of the database capacity so that we can push buttons and make sure that the documents are in the right place. We do not have the staffing presently. We really would need a clerk, a technical person that would be in charge of the computer aspects of organizing the data, the documents, and a docket clerk person, for lack of a better term. In terms of our legal staff, we were given a 3rd lawyer for the implementation of Act 181. And the reason why we were asking for the time delay is that, as you have seen, all of the other tasks that we're working on, and particularly the regional planning applications that are going to be coming in, we're going to be, as Janet mentioned, looking at 6 of those plans at once. So it's about the board capacity in terms of needing to push this off a little into the future, but that would enable us to actually build the system before we're flying that plane. And, and that would be really very beneficial, because at the same time that all this stuff is going on, there has been deferred maintenance for the rulemaking processes with the Natural Resources Board. As you know, it was just a chair, and then there were volunteer appointees. But this will give us an opportunity to update our procedural rules, which have already, our legal staff has already been working on that with regard to the other quasi-judicial functions that we are being given in terms of the regional planning approvals and Tier 1 mapping and all of that. And so this would give us the opportunity to take all of the changes that we are already working on and be able to update those procedural rules at the same time right now, if in fact the legislature would like us to go forward and be the appellate board. That process could all be folded into one. As you know, rulemaking takes quite a bit of time with the LCAR process and all of that. So if we could get all of that into our procedural rules this year, that, you know, that would be wonderful in terms of making progress and being ready to push the button on whatever the date is if we were going to become the appellate board.
And I'm not sure, did you comment on number 3 about A&R appeals, or maybe I missed it?
No, I didn't. A&R was just not interested at all. They are very satisfied with the appellate process that they have. They have a small universe of those, but they come from so many, potentially, they come from so many different programs within A&R that it was not palatable to A&R to be changing things for the appeals. And given the minuscule number of A&R appeals that are ever consolidated at the environmental division, literally like 1 or 2, maybe in a year at most, it did not seem like it was a problem to uncouple the ability to consolidate an A&R appeal with Act 250 or even with municipal permitting. So we, not only that, the board did not feel that we have the kind of expertise, technical expertise, to be sitting, to be reviewing that. We think that that should stay with the court. The other very important aspect of the court's jurisdiction that we have said should stay with them, that is our recommendation, and that has to do with enforcement actions. If there's a violation of a permit, or if people are developing land without a permit and they need an Act 250 permit, we have an enforcement arm of our organization, and that goes to the environmental division through a variety of different mechanisms, whether it's an assurance of discontinuance or an administrative order. So that we also believe should stay with the court. That is an arena that we should be a party in, not a decision maker, when we are bringing forth a complaint that the law has been violated. We're the prosecutor, and we want to stay the prosecutor, not become the judge on that. So that's very important that that stay with the court. The other improvements, let me just very briefly mention. This process was really very useful, even if the legislature decides not to change the appellate function of the LURB. We were able to, through lawyer Jim Dumont, identify a fix or a suggestion to the judiciary. Normally, a notice of appeal would be filed from an Act 250 permit decision, and then people get involved, they have time to enter their appearance, and then a couple weeks or a month later, the statement of issues on appeal was filed. And so there was this extra 28-day delay. And so the suggestion was, why not require the appellant to file the statement of questions which defines what it is that you're appealing. I want the court to re-decide this issue. So that there are different administrative agencies that, for example, require the statement of questions to be filed with the appeal. And so it was a very simple suggestion, and the judiciary has already put that into play. They're already going through changing their rule or attempting to. So that's wonderful that that came out of here. At least that will cut down a month out of that process.
It's a lot, yeah.
And the other thing that I would mention is that we are seeing some of the concerns and suggestions about allowing too much time in the parties to run the timelines of these cases. We have seen significant pushback that has been reported to us by the environmental court judges during this process that was incorporated by the stakeholders into their comments. And I do want the court to be aware of that. Right now, there's only 55 cases pending that are being worked on at the court. That's a small number. That is much better than it has been in the past. I don't have the stats, but we want to be very respectful to the judiciary, because just through this process in the summer, they are really endeavoring to address the concerns that people are voicing about timing.
Great. Thanks for all that. Representative Talibia, do you still have a question?
Yes. I like what I was hearing about streamlining and condensing the process, and then I heard the appeals going to the Supreme Court, and I immediately thought expense and time. Of the 1 to 3% that were appealed, how many of those that didn't go further, possibly didn't go there because of the expense and the time?
I don't have that number. We can certainly try to figure that out. Just by looking at the few cases that, I would say most of them would have gone up on appeal, would be my guess, but I will provide that information to you on this.
Can you give me an idea of average time once they go through the appeal process from beginning to end of the appeal? How long are we looking at? A year?
At the Supreme Court, you mean?
Yes.
In my experience of cases I've been involved with over 30 years, it can vary significantly. It can be a few months. It can be over a year. Over a year is not something that is, from my personal experience, that is that unusual or close to a year. There are a couple cases, 2 cases in our materials, and I can take a quick gander at that and chat with you later, or provide you with more information if you want us to look back at those appeals.
Okay, great. Thank you.
Mm-hmm.
All right, Senator Hardy.
I just want to clarify, because there's been some questions about it. What you're proposing, right now, the way it works is if somebody has an Act 250 decision on the local level, at one of the district boards, right now it's appealed to the environmental court. And then if there's an appeal after that, it goes to the Supreme Court. That's the current process, right? And what you're proposing is local districts still would have the first, decision, and then if there's an appeal, it would go to you, to the LURB, and then if there's an appeal from you, it would go to the Supreme Court. So that the Supreme Court thing is not a change from what the current process is. It's just the change is in the middle that you're proposing, is the middle thing. So just to be clear about that.
Yeah, thank you. I'm sorry if I didn't explain that.
No, you're doing great. I just wanted to make sure, because there were 2 questions about it, and that part isn't changing.
Right. Yeah, it's the appellate level, intermediate appellate level. Ultimately, in Vermont, you get to go to the Supreme Court.
Thank you.
Representative Austin.
Yep, I just want to thank you for working to expedite this process in a fair way. But, Vermonters have said it's unaffordable. People can't afford to live there. One of the reasons is we don't have housing. And one of the reasons that housing is so expensive, one reason, not the only reason, is the appeal process. And It adds money cost to the contractor, it adds cost to the materials that keep going up after a year, and it becomes unaffordable to provide affordable housing, I think, due to this, sometimes this process. So I just want to commend you, for trying to find a way to expedite this process so people can get housing built in a fair, they've already gone through several of the processes. So I just want to tell you how much I appreciate it.
Well, thank you so much. Let me just say, because I have spent my career representing all sides of these applications. I have represented municipalities, developers, large and small, as well as neighbors. So my goal here and all of our board was very concerned about, the job that we had in front of us, knowing that this has been a tug of war for many, many years. And I think that the goal was to figure out how to distill the best parts of what we have in our system and try to preserve those while reducing this cost burden. I spent 30 years trying to figure out how to represent people who didn't have money to be represented. And that's not talking about necessarily the neighbors. This is about making sure, as you're saying, that these costs don't escalate while we're sitting around twiddling our thumbs, or so it seems, about making decisions. We are committed to doing this very quickly. We have 5 people on this board. And so thank you very much for saying that. We really struggled and worked very hard to try to find something that was the right answer for the most people in this situation.
So
if I could just add really briefly too, just to give some data context to this, we had in 2025 we had 13 appeals, and that's both of jurisdictional opinions as well as permitting decisions, as well as an enforcement, I think, matter. We had 1 of those appeals was related to housing.
Yeah, it's a small universe. It's affected, but it is, I think you used the term, they've become the poster child of this tension that can sometimes happen. I just want to say, again, reiterate deep thanks to all of you. It's been a journey that we're all on. I'm having flashbacks to 2017 with the Commission on Act 250 starting in room 11, and many of the same folks are in the room here with us. So I just appreciate that we're in this really great transition to the professional board, and many of us envision this happening, and it's so exciting to hear your progress, and I look forward to continuing to learn more about it and working with you to continue to implement positive changes to Act 250 for Vermonters. So thank you. And members, with that, we are going to take a quick break, but we're going to transition to solid waste topic that's also of shared interest to both of our committees. But we'll come back together at the top of the hour to talk bottle bill. All right, welcome back to this joint meeting of House Environment and Natural Resources and Energy Committees. Shifting gears to talk about the bottle bill, and we have remote guests joining us to share a report that they authored to help us understand the status of the bottle bill and some recommendations. So welcome, I guess, Risa and Rachel remotely.
Great, and just checking, can you hear us and see us?
We can, yes.
Yeah, and apologies, folks. This is Risa Domino. I am unable to use my camera today, so but happy to see all of you. Just wanted to do a brief introduction and introduce myself, and then I'll hand it over to Rachel to make the presentation. My name is Risa Domino. I am co-CEO of RRS and a managing partner in our policy subsidiary, the Signifier Group. We are very pleased to have been chosen by the state to do this really important work, and in doing so, provide you with some data and information to inform your policy discussions. And so we're really excited to share the results of that work today with Rachel, which Rachel will walk through, and we look forward to any questions that you have and any discussions you'd like to have at the end. With that, I'll hand it over to Rachel.
Great, thanks. Nice to be with you all today virtually. My name is Rachel Perlman. I'm a consultant at RRS and with the Signal Fire Group. So I'm going to walk you through this. We should have plenty of time at the end for questions, but if there's any clarifying questions along the way, please feel free to jump in here and ask. So we're going to be covering the analysis we did, and here's just an overview of what we'll be talking about today. We're going to start with the key findings, just to get that up front, then go through the background and overview of the 3 models we analyzed for different bottle bill scenarios, go over the methodology in brief, focus most of the time on the impacts that we analyzed, the different material diversion rates we saw from the models, the cost estimates, greenhouse gas emission estimates, and litter. And then we'll end with next steps and open it up to discussion and questions. So we're going to go into what the 3 models were, but just as an overview of the key finding of the 3 models studied, Model 3, which includes program management by a PRO, a producer responsibility organization, and also the expansion of what would be covered under the bottle bill. That scenario, Model 3, performs the most favorably. And so it's the most cost efficient on a per container basis. Using that metric, it leads to the highest volume of diverted containers to recycling. And it has the greatest reduction in greenhouse gas emissions, and also, to the best of our understanding around litter, it has the greatest reduction in litter. All right, so just in review of what this study covered. Oh, is there a question?
Well, the posted presentation is not matching what you are walking us through, so we can't follow it on our iPads.
Oh, okay.
It's just backwards.
That I think that was the only.
If you go up, you'll find the background section. It's near the top.
And I think it's the last slide. The last slide. Yeah.
This is the only new slide, if that's helpful. So I think all of the slides should match going forward.
Oh, okay. Well, I don't know if it's, okay. You had a welcome slide. Anyway, go ahead. We'll see if we can get in sync.
Okay. Do you want me to give you a minute? Would that be helpful?
No. Oh, I see. Background. Okay, no, go ahead.
Okay. Yeah, we just added that finding slide at the beginning just so we didn't bury the lead. Yeah, so the Vermont DEC, the ANR of Vermont DEC commissioned Signal Fire Group to conduct this study and designated what the 3 scenarios would be. So we analyzed the cost and benefits, financial and environmental, associated with 3 models for the management of beverage containers via what's known as the bottle bill deposit return system, and also Vermont's regular recycling system. So just to overview our Vermont's current state of the system, the state currently has 54 redemption centers and 69 retail redemption locations collecting covered beverages. This is a total of 123 sites. The program places a 5-cent deposit on beer, malt beverages, mineral water, mixed wine drinks, soda water, carbonated soft drinks, ready-to-go drinks, etc., and then a 15-cent deposit on liquor. So most items have a 5-cent deposit. The study doesn't change any assumptions around deposit value. That remains the same. And the redemption rate is estimated to be 72% for containers covered by the bottle bill. And just a reminder of what redemption rate means, it's the quantity of containers redeemed in the bottle bill system, abbreviated by BBS, divided by covered containers, so the total amount of containers covered by the law. And in 2023, H158 was introduced, but did not pass, as you know, with the aim of expanding the scope of covered beverages. So there's still ongoing discussions. So hence this study. So this and the next slide overview the differences between the three models. Model 1 is the existing bottle bill system as it stands, and also the current recycling system. So no assumptions were made changing anything, only just trying to understand the current system for Model 1. Model 2 has a Model 2A and a Model 2B component, which are slightly different, but both are modeling a PRO-managed bottle bill system. So under this, all currently covered bottle bill beverage containers, except liquor, are managed by a beverage manufacturer distributor, PRO, producer responsibility organization. In this scenario, convenience is also increased. So a convenience standard is established to increase redemption sites, and this convenience level is similar to that described in H158. And another difference between Model 2 and the existing system is that because of the PRO, sorting by brand at redemption sites is eliminated. So that's a change. And all redemption sites must accept all redeemable containers, not just what they sell. So that increases convenience for the consumer. The difference between 2A and 2B, Model 2A relies primarily on bag drop systems as a form of collection, although there is a little RVM, reverse vending machine, in that model. And then Model 2 relies primarily on reverse vending machines. So it's the technology focus is different in those two models. And then Model 3, the expanded bottle bill, with the PRO is a version of all of the elements of Model 2, but then additionally expands the type of beverages included in the bottle bill deposit program as originally proposed in H158. And then just to put all of that information in another way of viewing it, you can see here the key differences between the models. So Model 3 has significantly more beverages included, with the exceptions of those listed there, the exempt beverages, and brand sorting is not needed at the point of redemption for Model 2 and Model 3. And then with in the current system, there's a commingling agreement that contains the majority of beverages, and now it's all beverages in the sense that there's no brand sorting required. And then in the current system, we have a handling fee set that's fixed, 3.5 cents for commingling and 4 cents for other beverages, for other beverage containers. In Model 2 and Model 3, there's no set handling fee. It's not fixed. Rather, the PRO negotiates the appropriate compensation for the redemption sites, which would likely be based on a per container fee. And then, as I mentioned, Model 2 and 3 have increased convenience. One thing that's not changed is DLL is still handling liquor in the scenarios 2 and 3, so that doesn't change. And then by means of having increased convenience, the number of redemption sites is higher for models 2 and 3. So instead of 123, we have 170 in the model. All right, I'll move along here to our methods. So the approach we took started off with data collection, and you'll hear a lot about the data and the results soon, and stakeholder engagement. So we conducted many interviews with redemption centers, and then we also talked to a number of stakeholders that I'll describe in the next slide to understand what data they had that might not have been publicly available already, and also just to understand perspectives on what should be included in the model. So what we modeled the bottle bill system, but we also modeled the recycling system. So beverage covered beverages containers are going through both the bottle system and the recycling system, so both are at play, and we have metrics describing both. We also modeled separate trips taken by consumers to redeem containers or recycle containers via drop-off, where drop-off is the mode of collection. We modeled greenhouse gas emissions for different scenarios, bottles from out of state redeemed in Vermont, the impact of eliminating brand sorting with the establishment of a PRO, and also modeling the impact of choice of technology and how that impacts redemption rates and consumer engagement. That's a high level. So in terms of the stakeholders consulted during this process, we talked to the folks listed here. They offered really helpful information at different points of the study and with key stakeholders that had have their own data on various aspects of this system. There was quality control in running results by certain stakeholders to verify that it matched or was similar to their own understanding of the system. And then some of these stakeholders provided data on things like litter to the extent possible. And then that interview piece was also really helpful. We spoke to 21 different redemption sites, so the managers or owners of those sites, to understand their current process and costs and how their operations could change under these scenarios. All right, so we're going to get into the impacts in just a minute. I'll just mention that there are a couple considerations to keep in mind when interpreting the results. So in Model 1, the current system doesn't have, as we know in the current system, there's not full compliance. So if there was complete compliance and full convenience levels, the Model 1 cost that you would see would actually be higher by an estimated percentage of 20%. So just keep that in mind, that that Model 1 would look to have higher costs if there were complete. And then Model 2 and Model 3, they quantify costs associated with increased convenience. That said, redemption rates remain the same. The expanded bottle bill systems can increase overall beverage container diversion by capturing more beverage containers. And these are coming from trash and litter, but also pulling containers from the recycling system. We'll go over that a little more. And then brand sorting, as I mentioned, is eliminated in Model 2 and Model 3. I'll just say that when we did those interviews with redemption centers, there was a very wide range of responses for what the impact would be on potential labor savings and therefore cost savings when you eliminate brand sorting. So the analysis we present reflects an average savings, but that impact would be sensitive to a change in estimate on the labor savings. So that could, you could always change that estimate and see a difference, but an average is used. So that could be just like just a note on the point of modeling. All right, so we're going to get into the estimated impacts of these models. So I'm going to start out with material diversion rates. So how many beverage containers are we seeing move to the recycling system? To recycled through either of the systems. So in Model 1 and Model 2A and Model 2B, which are the bag drop and the reverse vending machine models, the diversion of beverage containers through both the recycling system and the bottle bill system remain at current levels. And when I refer to diversion rate, just here at the bottom, that's measured by the containers redeemed through the bottle bill system and the containers recycled through, the blue bin recycling system or drop-off recycling system, divided by all containers. Those are the containers covered under the bottle bill system and the containers not covered by the bottle bill system. So diversion rate remains the same between Model 1 and Model 2, but in Model 3, there's an increased diversion through the expansion of the bottle bill. So that increased diversion is coming through the fact that more containers are coming to be redeemed. And then there's also some of the bottles are coming, as we mentioned, from the recycling system, and some are coming from the trash and litter. And then just a note here that diversion rates for all beverage containers include collection through both of the recycling system and the bottle bill system. So any questions on that point? So I don't want any confusion on the terms, because I know that can be a little confusing.
Yeah, Representative North has a question.
Thank you for the presentation. Just a question on the clarification of the terms. Is the redemption rate and the diversion rate, are those the same thing then, or are they not?
They're actually different. Yeah, and Risa, I don't know if you want to jump in with another version of an explanation, but I'm just looking at where we had the redemption rate.
Yeah, the redemption rate is the rate of redemption of things that are covered under the bottle bill system. So it's the containers redeemed divided by covered containers. And the diversion rate looks at all beverage containers and then everything that's recycled both through the container, but through the bottle bill system and through your curbside and drop-off recycling system. So there's a larger universe of containers as the denominator, because it includes things that are covered by the bottle bill and things that are not covered by the bottle bill. And there's also a larger numerator because it includes things that are redeemed through the bottle bill, as well as things that are recycled through curbside and drop-off. Does that make sense?
Yes, I understand the definition. Thank you. I'm just wondering then why you still chose to stick with the 72% as a diversion rate in Model 2.
Yeah, and that is, well, Rachel, do you want to explain that, and then I can provide maybe a more simplified.
So this actually wasn't like it was the outcome of the study showed that the diversion rate remains the same. It wasn't an assumption. The redemption rate, which is different, did remain constant as an assumption throughout all three models, because there's no data to show that redemption rate, which is not the rate being shown here, it's the other rate. There's no data to show that changes with increased convenience. So what you're seeing here is the output of the model. So it doesn't change from Model 1 to Model 2.
And basically the redemption rate is, let me see, I'm trying to figure out how to explain this, that why the model wound up with the same diversion rate in Model 1 and Model 2 is essentially the redemption rate is consistent across the board for bottle bill containers. The recycling rate is slightly lower, but applied to a larger amount of material because you have that all containers circle. So the recycling rate is applied to a larger amount of material. So it's a lower rate applied to a larger amount of materials, but it keeps the essentially results in the redemption rate and the diversion rate being the same. So that, as Rachel said, it wasn't a choice that we made. That was the output of the model. based on applying the recycling rate to all containers and the 72% redemption rate to containers covered by the bottle bill. So it is a strange coincidence, essentially. Did that make sense? Did we explain that clearly? It's a little bit, it can be confusing, I know.
I'll take your word for it.
And we can, this data is shown in a couple different ways throughout this. So this next slide might help. Hopefully it doesn't confuse further. So on this slide, the bar graphs are paired. So there's 2 vertical bar graphs for each of the 3 models. The first one is showing generation, whether the containers are covered or not covered. So the darker red are the covered containers. The lighter pink is not covered. So model 1 and 2 look identical because there's no change in, there's no expansion in model 2. Model 3 has expansion, so there is a much greater number of containers now covered in the system, potential for redemption. And then the bar graph on the right of each of the pairs is showing the disposition where these materials end up. The darker blue on the bottom of each of these is the containers redeemed. The slightly lighter blue are the containers recycled through the recycling system, and then the tan color is containers disposed. So you can see how model 1 and 2 look identical because of what we just spoke about, and these are in tons of material. And then in model 3, you have a greater number of containers that are redeemed. And then the total number of containers between the 2 blue colors, that total blue is increasing from model 2 and 1 to model 3, it's higher. And so that's representative of the higher diversion. This is just another way to look at the picture. So in model 3, more containers are covered by the bottle bill and more containers are redeemed. And this increase in containers redeemed occurs as containers are pulled from both the recycling and the trash streams. That's just another way to look at it. All right, I will keep going. So we looked at costs for the bottle bill system using both system level cost and per container cost. For the system level costs, you'll see that in the first row of the table on the bottom. So model 1, 2A and B have similar cost at the system level. So that 9.4 for model 1, 10.5 million and 9.2 million for model 2A and 2B. And model 3 has that's the highest system level cost to support the increased container throughput. So it's a larger program, more bottles covered. And on the per container cost, you'll see a different view in that you're seeing, everything divided by the number of containers. So model 3 is the most cost efficient on a per container basis at that 0.04. And this is because there's an increased throughput of containers, and there's an adoption of a strategic mix of technologies. So with this higher volume, there are what are called bulk reverse vending machines that can process more faster, and high volume redemption centers. So those would be in larger communities, more dense parts of the state, and a combination of retail reverse vending machines and bag drop to meet required convenience standards in other parts of the state. And then I just have a note here that if Model 1 met the same convenience standards required in Model 2 and 3, that per container cost would go from 0.05 to 0.059 dollars. So it'd be an increased cost if the current system had higher convenience. I'll pause here. Any questions as you.
Senator Watson
Yes,
has
thank
a
you.
question.
So in Model 2B, where that focuses on the reverse vending machines, in a prior slide, it mentioned that all locations that sell product would be required to redeem something about the 5,000 square feet. So does that mean that all of those locations would be required to have a reverse vending machine?
Most of them would. So that 5,000 square footage cutoff allows like small convenience stores and similar locations to be like the small ones to be exempt. And then in these scenarios now, all beverages are collected at all sites, not just the ones they sell. So there could be there's more convenience for the consumer. But yeah, most of those locations in this model would have reverse vending machines, but there could be some other mix of bag drop, but the primary mode would be reverse vending.
So even in the Model 2B, it could be a mix of reverse vending machines and bag drop.
Yeah, I think we were looking at specific factors that would be, I'd have to go back, but just like there are certain cases where reverse vending might not be appropriate. A more rural community might have bag drop.
Okay. Thank you.
Okay, and then so we just looked at the bottle bill system costs. Now we're looking at the recycling system and how these models are performing in the recycling system. So there's no change in the system level costs between Model 1 and Model 2 for the recycling system. There is a 2% increase in system costs for Model 3 due to the loss of revenue resulting from the expanded bottle bill. So some of those high value containers may move from the recycling system to the bottle bill system, decreasing revenue. And then container costs is reduced for Model 3 as fewer containers are recycled through the recycling system and instead recycled through the bottle bill system. And then on the per container side, Model 1 and Model 2 per container costs are the most cost efficient across both bottle bill system and recycling system on the per container costs, while Model 3 is less cost efficient in the recycling system on a per container basis. Largely due to the decreased throughput. So the main thing you're seeing here is the recycling. In the recycling system, the per container cost is increased in Model 3. So this is because we're looking at it from the recycling system lens. And in the next lens, we'll see the full view. So here we're looking at the overall financial cost of the combination of the two systems at play, the bottle bill system and the recycling system, and it's weighted to understand a per container cost overall. And what we see overall is that Model 3 has the most cost efficient outcome on a per container basis. And this is given the reduction in costs with elimination of brand sorting, the increased efficiencies through technology adoption that we were speaking about, and management by the PRO, and then also the increased overall volume of containers collected. So the kind of the benefit of scale there.
Can I ask a question? You may. Senator Hardy. Thank you, Madam Chair. I'm just looking at these two slides. I understand
I think it's slide 16, where the cost to the recycling system, that's to the, what, their MRFs, right? Am I getting that right? To those of you who are recycling experts. And the overall financial cost on slide 17, is that a combination of costs to the MRFs and costs to the redemption centers, cost? What I'm most interested in is cost to the consumer, or cost to the average Vermonter. So what's the cheapest option for my constituents?
Yeah, I'll answer, and then maybe Risa, you can also speak to this. So we, none of these slides speak to the actual cost to the consumer, because in that sense, the cost doesn't change on the deposit, but the overall financial cost, I think, is the cost that best answers your question, because it is the cost to society, which then impacts, things like ratepayers. So this is the best metric for the overall view, because it does include, like you said, the recycling system encompasses the path that goes through the MRFs, and the bottle bill system encompasses the path through redemption centers. And then this slide demonstrates a weighted picture of both systems in combination.
And does this model 340 cents include what might be the potential cost to transition to the model, or is it just once we get there, it's 40 cents per bottle?
It's actually 4 cents.
I'm sorry, 4 cents. Thank you, Scott. 4 cents.
Yeah, this is the cost when we're there, not the transition cost.
Okay, so overall, expanding the system and increasing the number of containers that are relevant or covered is cheaper in the end. It's just the transition cost. And do you have a slide that shows that transition cost?
No, the scope didn't focus on the cost of transition.
Okay. Okay.
We're working on figuring out the cost of what it would cost to set up the PRO.
Okay, cool. Thank you.
Representative Sakowicz.
Yeah, your models have a lot of numbers in them, and it's my understanding is that the vast majority of these numbers are estimates. And so I'm wondering, how good are these estimates? Like what's the uncertainty in the numbers? Because when we look at the current slide, we're seeing numbers that are fairly close. And if we're going to be using these numbers to think of one model as being better than another, if the error bars around these numbers are significant, then we could easily see the order that we would place the costs change dramatically.
I think that's fair. But I also want to point out that these estimates are based in reality, in actual program costs, information gathered from stakeholders in Vermont. And we did, review these data with the Vermonters who were involved in these programs to, as Rachel said, do some quality assurance, quality control on our approach to make sure that what we're presenting here is as realistic as possible. We also draw on extensive experience within our Essen Signal Fire group and in looking at these programs around the country and around the world. So I think they're very well grounded. But yes, they are estimates. We don't have hard numbers until something actually gets implemented. But I would also point out that the financial cost is one piece of the picture, and Rachel's about to walk through some of the other pieces as well. And so I think the full evaluation is a bit more clear. But yeah, to your point, there are no guarantees that these numbers will be absolutely accurate, but we did our level best to get real data and information to feed into these models. So I think they're as strong as they can be.
Yeah, I no doubt that you did the work necessary to come up with the best numbers possible. My question is really about, like, when we try to evaluate the meaning behind these numbers, if these numbers were all plus or minus 1%, that would have a certain meaning. If these numbers were all plus or minus 10%, that would have a very different meaning.
Right.
And without knowing where we're at least roughly speaking, I find it hard to make sense of these numbers. When they're presented here, they're presented as a comparison, 0.043, 0.047, and the implication is that the 0.043 number is lower than the 0.047 number. And that would be true if we knew that the errors around your statistics were very, very small, which maybe they are. But if the errors around your numbers were substantial, which maybe they could be, then this comparison would be a lot less meaningful. And so without knowing sort of what the uncertainty is with the numbers that you're presenting, it's really hard to make any sort of decisions based upon the numbers that you're showing us. It's not helpful.
What about, do you have error estimates?
So we did do some sensitivity analysis where numbers that had to be determined through understanding costs from stakeholders and having a range and then testing different levels and their impact on the output. That scenario analysis was tested, but in some cases, quantifying uncertainty just wasn't possible with the data available. So the strategy we took in most cases was trying to verify the data used going into the model. So verifying things like sales data, actual cost data, cost of the different stages of handling things, understanding like the average distance of trips taken by consumers and how would trip travel, those travel to drop off, how would that change? So I think the real Vermont data was used in any case where possible. So I don't know, Reese, I don't know if you have any other things to add on how we reduced uncertainty, but it is true we're not showing error bars between these three values, and I understand the value that would provide.
Yeah, I think the other thing I would just say is that I think the relativity between these options would likely hold even if the numbers were slightly different, because the differences in cost are based on factors like the bag drop is a higher cost because there's an additional processing system required in a bag drop. That's not going to change if we misaligned on exactly what that additional cost was. It's still going to be relatively more than the other. So I feel fairly confident that the relativity among these options would hold even if the numbers were to change a bit.
Josh Kelly.
Thank you, members of the committee. And for the record, I'm Josh Kelly, Solid Waste Program Manager at the Agency of Natural Resources. One point on cost is who's the cost to as well, and what's changing in the models from model 1 to 2. And I'm lumping 2 just for the sake of simplicity. The cost you're seeing here, who's paying? Distributors and manufacturers are paying some of this cost, and when we shift to more standard producer responsibility models, that's traditionally 101, is you shift the cost burden of managing materials at end of life to producers of it. So a lot of that cost is there with producers in model 2, and I'm less so on retailers. There's a lot of retailer cost in model 1 that's not fully realized. That little tiny number 9 goes back to 20%. If all of Vermont retailers were compliant with bottle bill, taking back what they're supposed to, there's an estimated 20% extra cost there. which I don't think we can downplay in how the bottle is working today. And then the recycling system, the regular place where many of our cardboard boxes go, takes some loss when aluminum comes out. And so they have a cost here as well, and that's in these numbers. So it's not just the consumer per se. And as we shift to more producer responsibility, more of this cost is really with beverage makers at the end of the day. I hope that helps. And so there's some, when you shift to Model 2, there is some changes to infrastructure, and as this report does say explicitly, who ends up paying that more, and beverage makers pay more of the cost in everything but Model 1, and retailers start to pay a little less. The other piece is the handling fee, which is on every single container. So it seems like not much, but every container has that handling fee. And those become more of a negotiation under these other models. And they could change potentially. It could go up, they could go down. It's hard to predict where they are. When you don't have to sort anymore, what do we need to pay? And to your question, there is a chance that there's still manual redemption because you're only sorting by material type. So using your hands is actually pretty quick instead of having to have a big machine. So there was some assumption that some of the manual sort will continue, but it's just much faster than it's ever been. Sorry, just context there.
I want to be sure we get through this before the noon hour. I want to do a public service announcement that updated slides have been added to the webpage under the first word in the title is updated. So if you want to, I don't think the end of the slideshow is different, but just so you know, they have been posted.
Great. Yeah, so these are the other impacts that we measured. So we looked at greenhouse gas emissions, and we saw that the greenhouse gas emissions were estimated for beverage containers managed through the bottle bill system and the recycling system using EPA's waste reduction model, WARM. And we supplemented this with additional consumer trip information. Most Vermonters are driving to locations. So Model 2 yields a slightly higher environmental benefit. So when I say benefit, it's a reduction in emissions. So that's why there's parentheses around these, because they're negative, they're savings. And so Model 2 yields a slightly higher environmental benefit than Model 1. This is mostly due to reduced transportation emissions associated with a higher number of redemption locations, shorter trips. And Model 3 provides the most significant environmental benefit, the greatest savings compared to Model 1 and 2. So you can see that by the larger negative number. I'm going to keep going for the sake of time, but we can always take questions on that. So litter was estimated. Litter estimates are expected to be the same for Model 1 and Model 2, with a slight decrease in Model 3 as a consequence of expansion. So in Model 3, litter decreases by about 22%. So that's from 411 tons in Model 1 to 322 tons in Model 3. The estimates were done using the following data. Volumes were based on the best available, but an older study from 2009 by Keep America Beautiful, and then also discussions on Green Up Vermont. Composition of litter was based on data from 2021 Keep America Beautiful study that suggests a composition of what's written there combined, and that data was combined with per pound conversion factors. So what kinds of litter you'd see in this scenario would be 6% cans, 7% PET, 1% HDPE, or number 2 plastic, and 86% glass by weight. So that weight factor matters because glass is heavier. And the estimated reduction resulting from expansion is estimated to be 40%. This is based on findings from a New York study that looked at the impact of expansion on litter between 2008 and 2015. So we made an assumption that there would be similar behavior in another northeastern state, which is certainly an assumption with potential limitations. So not a lot of litter data available out there, but we used what was available. So those are the metrics that were analyzed in this study. Just in brief, you have the report here, but it's also available on the DEC website. The report has metrics on cost, material flows, and environmental impacts. It's intended to support evidence-based policy decisions, and we're certainly available to answer questions. So with the remaining time, we can go back to any of the discussion that would be most helpful.
Yes, and I want to make sure Josh has time to share what he came to share with us. So maybe we'll move to Josh.
Thank you. Thank you, members of the committee, Madam Chair of each committee. Thanks for having me. I'm Josh Kelly from the Solid Waste Program at the Agency of Natural Resources. I've talked a little bit already about today's bottle bill, but I think I'll just summarize and say it's a fairly broken system right now. Established in the 1970s, we're hearing and experiencing that consumers are finding it harder to redeem their beverage containers. Not all retailers are compliant with taking back beverages, and redemption centers, where most redemption occurs, are struggling with the high sorts. They have over 100 grams they're having to sort at any one given time. And we've seen some closures and reductions in services as a result, direct result of the strain. The bottle bill is a form of what we've talked about in this chamber of extended producer responsibility. It's if you sell a beverage that's covered, you have to make sure you have a pickup agent, you carry the deposit, and you remit the nickels. And essentially make retailers whole for the nickels that they paid out, and then it has to be collected back. But it lacks many of the convenience standards that we have in other Vermont EPR programs. So we have our battery program, our paint program, our electronics program. It lacks some of the convenience standards and efficiencies that make those so successful. And really, we feel that modernization is needed before we go to expansion and include more beverages. We feel like there's a need to make the system work better first and test that out. The report that you've just heard about is exhaustive. It's taken me many months of working with these folks to go through it. And it represents Model 2 and 3 agency-developed assumptions as to what would work best in different future states. So one of the things right out of the gate is Model 2 doesn't really show cost is a major part of this report. And Model 2 doesn't really show a difference in cost, but it is our opinion that it's likely to cost less over time. For example, the Model 1 20% cost could be increased if all retailers were redeeming as they should. That's not insignificant to me. And further, when redemption centers were asked about the decrease in cost for sorting, it was a mixed result. 60% said, yeah, there would be some elimination. Brand sorting would help us. We'd get some cost savings there. But 40% said it wouldn't save them that much. And so it was hard for us to, what's the motivation there? Keep in mind, redemption centers have been paid the same handling fee for years and literally decades. So their costs haven't really been able to update with the times. So that may be something in that data. What we have heard from redemption centers is that sorting is really crushing their ability to continue doing this practice of redeeming containers. And we've seen some close and some, as I said, cut back hours. So I think that Model 2 would likely cost less than Model 1. And then Model 3 will cost more overall. It is likely that moving from Model 1 to Model 3 will increase the bottle bill system cost, just that bottle bill system cost, by an estimated $4.6 million per year. And it is the most efficient on a per container basis, but it's important also to look at the whole picture as well. Both are important. And then lastly, diversion or recycling rates, we get very confused by this, and I apologize. It's funny that the amount of containers that we redeem is 72%. And our overall, how good is Vermont at recycling our containers? Overall, all the containers of beverage containers, it happens to be 72% as well. So that is going to trip us up every time we talk about it. I apologize. It happens to be right there. A recycling rate and diversion rate is the big umbrella, and then redemption is a piece of that. And the bottle bill is very effective at getting, I mean, 72% is good for a state for a redemption rate. Massachusetts is more like 50. That's just more detail. So Model 2 is also, in our opinion, likely to see some recycling increases. While the report shows no change in diversion rate or recycling rate, this is mainly due to lack of available data, and it's in the detail in the report. But based on the agency's experience, when we have had increased convenience for consumers with paint collection or battery collection, we see recycling rates go up. So in our experience, some increase in convenience will help the system. Model 3 will increase recycling. This is the one where moving from Model 1 to Model 3 is estimated to increase recycling 13 percentage points, 72% to 85%. And those bottles and cans would be pulled partially from the regular recycling system. That's that 2% increased cost, which is an estimated $903,187 that the recycling system would lose out on. A little less than $1 million per year. And then some bottles and cans that were previously disposed of in the trash and littered would also be captured. So that's a net environmental benefit. That really concludes my testimony. Make sure I give you guys time to ask questions.
All right, do members have questions?
Yeah, I think I can do a
Representative
quick question. So I really appreciate the points you just made about that there's certain factors that weren't modeled adequately because we just don't really know how to put a good number on them at all. And so we didn't include them, and that you're trying to sit here and tell us, well, we should think about those things because they are important and we know they're going to make a difference, even though we don't know what the difference is. I think it really muddies the water, but, in a sense, because we're given this model, which seems to be based on these very hard numbers, but then we're saying, well, there are these important factors here that we're not including in our model because we can't quantify them. It seems like it would be helpful when we get numbers to be able to have sort of scenarios with numbers associated with them that say things like what you just said, but in the same sort of format where we can say, here's what the model would tell us if the rates, if the convenience rate, if the fact that things are more convenient increase the recycling rate by 5%. Here's how it would change our model, that kind of thing. And then we could get a sense of the sensitivity of the kinds of things that you're saying weren't included. It would just give us a better feeling for how the changes would actually affect those numbers.
I tried to tie my testimony to two core things, cost and recycling. Is the juice worth the squeeze, so to speak? 13% is not insignificant in change from 72% to 85%. And that 4.6 million, because these models all predict sort of a producer responsibility type model, that 4.6 million of extra cost is really, as the report says, it's mainly distributors and manufacturers that would bear that cost. And that's what our battery program is like. Duracell and Energizer pay the cost of our recycling. We have one of the best battery recycling rates in the country. So it is hard to know these per container rates, and these costs are 100% ground truth. And you probably will testimony, people have differences of opinion. This is a very hot topic. I think RRS did a pretty good job getting the data. And then you get kind of sometimes scratch your head results when you say to a redemption center, we're going to stop brand sorting. How will that improve things? And you don't hear, oh, that'd be wonderful. It's a little scary to think about change, I think, for everybody. So I don't know if that fixes everything you're saying, but there is some cost here, and it's going to be borne by some people for sure in the system. I'm sure you will be testifying about that.
My thoughts are more just around, as I'm trying to make sense of this, the places where I'm going to go first is going to be these charts and tables of numbers.
Yeah.
And without having the additional context and how that context affects those numbers sort of baked in a more transparent way, it's just harder to do the interpretation.
And we have this contractor on retainer to come and speak again if you'd like, at least one more time. And they've been very helpful. So if you want to dig into it, we might.
All right.
And just to add quickly on that point, there aren't any instances of a deposit program that has improved convenience without also increasing the deposit amount. And so we weren't able to identify what the improvement would be from just increased convenience. So that's what the analytical challenge.
That's a very helpful piece of information. Thank you. It's like the end of the first episode in our conversation. Got us to